Honolulu. The city and county of Honolulu brought me out over a period of a month or more to train all of the supervisors of the city and county of Honolulu in use of force, firearms, batons, and other aspects such as OC, pepper spray, and pursuits. And I taught the entire staff of supervisors. It's a 200-member agency and have a lot of supervisors. In the initial of that, all the members of the Administrative Review Board, those that sit in judgment of police officers, wanted to hear from me first and see what it is that I would be presenting, and then I taught the remainder of the time to the officers. I did that around the clock. Teaching in particular areas as well.
Well, let me ask you this. Isn't all the police departments have different policies and procedures on use of force?
Not really. They vary some. However, most are guided by recognized procedures. We are 50 states that 48 are contiguous, all fall under the basic same federal guidelines coming through the Supreme Court decisions. So use of force is generally very, very similar in terms of the objectives, the tactics. Sometimes larger agencies have more detail and maybe are somewhat more restricted than the smaller agencies who are more rural and less support for them. But the training is pretty much the same throughout the country. Having taught officers from all AELE, street survival, and individual agencies. The Police Academy on a continual and continuing basis. Next Monday, the 1st of June, I'll be up for a week of training on pursuit and high-risk and follow pursuit or high-risk vehicle stops. I'll have a week in all the scenarios with the vehicles out in the field and going through all the potential possibilities of tactics and how to control, set up perimeters, arrest, take into custody.
You're training with police officers. You said supervisors and troopers and officers themselves. Have you done any training for administrators,
yes.
prosecutors, attorneys, things of that nature?
Yes. Through I mentioned AELE, prosecutors and have trained in the neighborhood of 10,000 been heavily involved in the training and education area as well, and I participate with the legal officers, the women's section, as well as the psychology section of the Association of Chiefs of Police. I now have been a member for about 46 years. I am a life member of the Police Chiefs Association. I'm a life member of the National Sheriff's Association, and the four organizations, but those are the more relevant and pertinent ones that have policies, procedures, or impact law enforcement officers that I'm involved with.
And you teach?
I have taught the academic portion as well. At one point, I was the department chair of the criminal justice program at Tallahassee Community College, where I formed the program, hired the professors, supervised the professors, and taught. I taught basic law enforcement classes, as well as 2 courses, intermediate and advanced, on criminal investigation, as well as criminalistics, 2 classes for private forensic evaluation, trajectory, blood spatter analysis, cardiac case evaluation. I don't keep an accurate count, but I would say it's certainly in the neighborhood of 200 federal, state, or criminal court.
And of those, how many?
Very few were criminal. I'd say under 10 were criminal, involved with criminal cases, not criminal like citizens, but police officers, or police officers were charged with criminal activity. Less than 10 probably.
And the remainder was civil?
Civil. No, because we're at risk, of course, in the field. Mine.
Represented or been involved in these hearings?
Yes, I'm to the civil. I was involved in handling the force that he was involved in. I've also testified in hearings for and against officers in the circumstances, and I have been retained by the organizations representing the police officers to assist with their defense as an expert, coming in to mind about the police procedures that I believe they follow, and I have also been retained by the agencies of law how the officers did not comport with policy, procedures, and Constitution.
So you've been on both sides of the aisle, so to speak, based upon the context of the case. Would that be a
based on the facts of the case, that's correct. And those that I named, Houston, State of Washington, in Des Moines, Iowa, Miami, State of Florida, those are all relatively recent, and they are one or the other. In some cases, I was retained by the officer, his or her organization. In others, I was retained by the state
retained by police unions?
Numerous, yes, numerous have. I've been retained by the attorneys that represent organizations of law enforcement, sometimes referred to as unions. There are done. It's compensable, and I believe it should be. I testified widely for the attorneys representing unions about that particular employment issue. That's outside of use of force, but it's still engagement for the case.
Okay.
Largely through the Graham versus Connor or Tennessee versus Garner, two of the outstanding ones. There are many others that have come down in terms of guidance on pursuits and whether or not they are or not, how they reach the standard for constitutional violation if they do.
And that's part of what you train, correct?
I train that. That's correct.
Okay. Tell the court what is universally similar throughout the United States regarding this.
In what area? In use of force. Yeah. Officers are trained that they are going to be judged by the standard of whether or not their conduct comported with what other similarly situated or trained officers would actually do under the similar circumstances, because it should comport in other words, how I may want to handle it right now. That would be subjective. An officer they have to have a subjective analysis in order to know that they're acting objectively, but they must act objectively, irrespective of their subjective belief. At the time, they have to apply the objective analysis. The objective analysis is basically comporting with to that. Then, of course, you've got other issues, for example, and law enforcement officers are trained them, and it's in the procedures and it's in the policies. There's a three-pronged test that's going to be evaluated. The seriousness of the crime, whether or not the subjects are fleeing, eluding, or attempting to resist the officers, and whether or not the officers at the moment the force
is unique as far as dangerousness?
There's an assessment, and officers are taught threat assessment, threat analysis, and threat prevention by using contact and cover and other procedures. So obviously facts drive a case, but the facts of the case are
because they're in fear of their life, are they supposed to disregard their training?
that's why we train them.
There's an objection.
That's why we train them, so that when there is fear or adrenaline, they revert to what they know is the proper course of conduct. That's done under similar circumstances.
Subjective concept into this, as far as police officer goes, when he's confronted with this dangerous situation?
As I indicated, yes, there is a subjective analysis, but the actions have to be objective. In other words, you could not, without putting in some
Okay. And sir, you were in this case.
I was called by Mr. Philip Bogdanov and asked if I would consult with him on a file that involved this particular shooting.
And did you have conversations with the prosecutor's office after that?
After that, I did, yes. The prosecutor's office paid my time.
Including today, correct?
It will, yes, that's correct.
It will, okay. All right. And what were you asked to do?
I was asked to evaluate a file of materials that included the BCI, the Bureau of Criminal Investigation, the
As a police officer?
pursuits.
Yes.
Yes, there were some.
Okay. Did you ever have to execute deadly force at any point in time in your career as a police officer?
No, I had deadly force imposed against me. I did not utilize deadly force.
Okay. Did you ever shoot your gun when you were on police officer?
Did I shoot my gun?
Yeah.
Not in the line of duty, no.
Okay. So never came a time where you had to actually shoot your gun in the line of duty?
I never had to.
Okay. And sir, let's get back a moment before we get into your opinion. You talked about the use of force throughout the United States. How about pursuits? Are pursuits similar throughout the United States as far as the policies and procedures go?
Thank you for clarifying the policy.
Yeah.
Pursuits are not similar.
Right.
They are factually driven with different circumstances, but the pursuit policies are virtually identical. That's because the International Association of Chiefs of Police, for example, put out a model policy for pursuits. They actually met the chiefs themselves collectively from throughout the United States met in Phoenix in 1996, and they personally put their stamp of approval on one model policy that took into consideration the various similar now and recognized tactics and procedures for pursuit. So that organization, being the largest, most prestigious body of administrators, obviously writing a policy from the police chief's perspective from throughout the country and being adopted as the model policy, certainly was picked up by the other agencies that were not present and by other training academies, and it's by and large taught similarly throughout the country, and the wording is very similar. There are some individual nuances around the country that allows some things versus others by state law. Like Virginia, for example, allows police officers to exceed the speed limit for a brief period of time just to get a clock on a car, which then may turn into a pursuit. Other states do not allow that discretion and require lights and sirens. That's just one minor nuance. Sometimes there's a little nuance like that by state law.
Okay, but you went through the use of force, the general concepts and practices based upon court rulings and things of that nature. How about with the pursuit policy? What is that model? How many cars are supposed to pursue according to that general policy?
Throughout the country, it will state 2 cars maximum unless supervisory authority is given.
So, and also, these policies are driven clearly by each particular context of each particular pursuit, correct?
By supervisory intervention. In other words, there's a caveat. 2 is the standard, and depending on the circumstances, a supervisor will either on his or her own or through a request modify what they may do in terms of numbers of vehicles involved.
Based upon those circumstances.
Based upon what is known at the time. That's correct.
And there's a concept, I should say, or a policy of practice, a term called active shooter. Does that have anything to do with what we're talking about?
Well, a little. It was the term active shooter was not did not come about as a result of police officers in pursuit of someone and the shooting occurring at the time, but more related to and became obviously more intently looked at as a result of the Columbine case, where there was in a building a moving active shooter. And the active shooting training does not relate to a pursuit in the training academy. It relates to the active shooter at a specific defined and location, a school, a campus, a convention center. That would be more the term. However, I wouldn't disagree that if there is a shooter and it's actively occurring, but it's moving, although that wasn't the reason for the term, I wouldn't say, well, no, you couldn't call that an active shooting situation.
Okay. So you would agree with me that the fact that there is a perceived threat against police officers, that police officers were shot, that is high on the I should say, list of dangerousness. Wouldn't you agree with me on that?
As I tell them in the training class, somebody shooting probably gets your attention more than anything else that you will do. That's correct.
Okay, so that's pretty high on the list.
It's the highest.
Right. People shooting at police.
People shooting at the police would definitely, well, or the police shooting. I mean, it's all considered high. Deadly force is obviously at the top of whatever you want to call a continuum or constitutional standard. However you train, either way, shooting is at the top of the list.
And if you have this situation where you're at the top of the list, do you disregard your training and policy and procedures to eliminate that?
Well, no, quite the contrary. When you have a deadly force encounter and a shooting situation, that's when we want the training to basically guide almost as if you're on autopilot, because we want that training to be ingrained so much that no matter how much adrenaline or what's going on in your mind or how fearful you are at the moment, The training overrides that so that you stay safe, the subjects aren't excessively handled in a manner that would be considered excessive force, and no one else is injured or killed as a result as well. There are a host of things to consider. The environment, the suspects, other officers, yourself, all of that has to come together at the time that the shooting occurs, more than probably other circumstances.
But each dangerous situation is unique, correct? I mean, one pursuit is going to be different than another pursuit. Isn't that correct? One use of force could be different than another use of force.
Well, that's called facts.
Right.
Reactions are supposed to be similar. So reactions are not different. The reactions should be similar. The facts may be different, but your reactions, cover, contact, concealment, assessment of the environment, crossfire, backdrop, those are all taught so that when you're getting blurred with the circumstances around you, those words, those procedures, those scenarios are at the very top of your mind so that they automatically kick in, because that's when you need it more than any other time.
Now, you said you're still training police officers as we speak today, correct?
I am currently and have consistently for 48 years. I've never been out of the practice of training police officers, and I said my next assignment comes June 1st, high-risk encounters with vehicles that you are engaged with, including use of deadly force.
Well, how does military training factor in any of this?
Well, that's interesting because now in the police academy, we are experiencing a high percentage of the classes are enrollees from the military. Obviously, we have been engaged in
a war,
or maybe several wars, or at least circumstances that certainly look like war, even if they haven't declared it through Congress as a war. It certainly looks like war. And as a result, there have been many active duty call-outs and deployments. Because of that, and as they phase out of either retire or come back to reserve status or are sent home to wait for potentially other deployment, they're getting involved in the police academy. So we do have to address in the police academies now more than ever, and there's a lot of research going on as we speak about how to train former or current officers coming on the police force who have been military, because there are two different sets of engagement rules. One is a military engagement and the other is civilian.
Yes, he did.
Actually, I don't see that in his report.
Yes, he did. Last page, Your Honor. He mentions it. I'll get to it if I can find it. There we go. So he was not combat the civilian police operation. So he's making this distinction right now, Your Honor. As you know, the expert reports are a general outline of what he's going to say. He's going to fill in the blanks, so to speak, and he mentioned it right there, the difference there.
But he doesn't say that the tactics are different. He said nowhere in his report until page 11 until page 12 is the question of whether Brelo has military experience addressed. Nowhere is the military standard or the military rules of engagement addressed. And then his final sentence is, open quote, he was not in combat, comma, this was a civilian police operation which dictated he continue his position of cover, comma, assess and give verbal commands, close quote. So the objection is sustained.
Well, Judge, he's explaining exactly what he meant in that sentence.
I didn't hear him to say that. I heard you to say, and I'm paraphrasing because I don't have it exact, although I'm sure Mr. Lloyd does. I heard you to say,
are there different rules of engagement for civilian and military?
And that's what he mentioned there, Your Honor. He was not in combat. That's what he meant. He's not in combat. So what does that mean? It means he wasn't in combat. And there's different rules in combat. It's not going to get into the military rules in combat. Just the fact that there are different rules between civilian and criminal. And military.
Where does he mention that in his report? It's here, the objection is sustained. We can have the next question.
Okay. It's a very good question. Sir, when you said he was not in combat, that this was a civilian police operation, which dictated continuous position of cover, assess and give verbal commands, what did you mean by that?
These are civilian rules of engagement as opposed to military rules of engagement.
Okay. And in your training right now with police officers, what's the percentage of police officers who are ex-military people?
Well, different classes, sometimes as many as 60%, sometimes less.
And when you do these training classes, is there questions by the military people regarding the difference between these two?
Yes.
Well, that particular question is non-objectionable.
So overruled.
Okay. So there is a difference.
Yes, and we have to explain it because the research has indicated, and the police chiefs...
Hold on. See, this part is sustained,
Because I don't see these opinions in your report, which was to give guidance to the opponent about the subjects of your testimony. So we'll take the next question.
Thank you, Your Honor. So there's a difference, right, between military and civilian.
Yes, that's correct.
So, sir, we're getting back to this case and what you reviewed. We marked your particular consulting report, and and by the way, sir, your opinions, are they to a reasonable degree of professional certainty?
Yes, as I indicated, that's correct.
All your opinions that you're giving to the court right now?
Yes, based on my training, education, experience, literature in the field, tactics and procedures and training that we get from court decisions and that are generally agreed upon by agencies, administrators, and organizations that direct law enforcement.
And, sir, it's not to the reasonable degree of scientific certainty because you're not a scientist, right?
Yeah, generally, what we're speaking of is an art form, not a science.
Okay, but I'm saying
That's right.
It's not to a reasonable degree of medical certainty because you're not a doctor.
No,
It's a reasonable degree of professional certainty based upon your training experience.
that's correct.
Okay. All right. So, sir, you're able to review the whole file, correct?
Yes,
And you're familiar with the facts and circumstance of this case?
yes.
And, sir, let me ask you, in your opinion, was there a reasonable perception that these individuals in the blue car were shooting at police?
At what time?
From the beginning.
Yes, I did opine that I believe that mistakenly, as I testified earlier about mistaken belief, mistakenly, but because of the information that they were hearing, some of the movements that they saw, their interpretation of those movements, I would have to say that it was a reasonable perception overlaying the noise that was being made by the car, the initial backfiring, that I think there was agreement. It sounded like a gun firing and the car speeding, fleeing and not stopping for the police. That gave more impetus to believe. And then the radio was crackling with all kinds of assessments and thoughts, and officers may rely on that kind of information to reasonably make some decisions.
And do you know how long this chase was?
25 minutes, I believe.
And in your experience, is that a long or a short chase?
In all the California standards, it's a long chase. For some reason, they appear to go on for hours sometimes, and we only see that, I don't know why, but generally in California.
Okay. So this was a long chase by police standards.
Long chase by police standards.
Okay. And, sir, you were talking about this reasonable belief. Even though all these assumptions, or I should say interpretations of the victim's movements in the car, even though they're all interpreted one way, it still was reasonable by the
Yes.
police.
It's very borderline, but I called it reasonable because you know, reasonable is an elusive term anyway, and you have to look at that reasonably. And if you do, you can't start saying borderline reasonably. It was basically mistaken, but I believe the mistaken belief was reasonable.
And there was one mistake.
Move to strike. Overruled.
And there was one mistake on top of another mistake during this whole chase.
Which kind of kept the thought going that it was reasonable but mistaken.
So, all the officers that were engaged in this pursuit, to the point they got to the Heritage Middle School, in your opinion, they had a reasonable belief that there was an active shooter in a car fleeing them, correct?
Yes.
We can all agree on that, right?
Yes.
Okay. And so you opined as to a number of things that occurred during the chase, correct?
Yes.
And you opined on Officer Jordan, correct? The initial
Yes.
stop. And you opined on all the officers that were inside the middle school parking lot, correct?
Yes. I opined listening to the audio, reviewing the transcript, seeing what they heard, overlaying it against the descriptions. I couldn't help but believe, obviously mistaken, but reasonable.
Okay. So now, would it be safe to say that your attention was directed to Officer Brelo's actions then, correct?
It got to that point, yes.
Okay. All right. So you are familiar with the facts and circumstances that occurred at the Heritage Middle School?
Yes.
Okay. So we get to Officer Brelo's actions, correct?
Correct.
Now, you opined on the other officers there too, correct? As far as their reasonable belief and their use of deadly force?
Yes, I made assessments about everybody, their movements, their beliefs, how it interfaced with basic training, the police interface with a shooting potential situation, yes.
Okay. So we're talking about Officer Brelo. How many shooters, do you know the number of shooters that were involved in this total?
13.
And that's including Officer Brelo, correct?
Yes.
So the other 12, you opined, what was your opinion as far as the other officers? You have 12 other officers and their use of force at that point.
I very carefully looked at what each of the other officers were doing and how they did it and how it comported to training, if they were reasonably making decisions based on information that they were taking in and how they acted in response to that. And when I looked at that, I came to the conclusion that although mistaken, they had a reasonable belief, and they acted and comported with police training, which made it objectively reasonable.
Okay, and that was each individual officer's actions, correct? The other 12?
At some point, that's correct.
Okay. And, sir, when you come to Officer Brelo, could you tell the court what you found with his actions?
Well, I opined that even the shooting at the time when Officer Brelo went into ambush training mode that they had just a few weeks prior and shot through his window.
Okay, let's back up a little bit. What is ambush training?
How an officer who is unexpectedly attacked while in his or her patrol car can and should respond, because that has been an elusive area for many years, and it still is with most agencies. What do you do? Do you flee the area? Do you put it into active shooting mode? Do you respond? We've never trained to shoot through windows of our patrol car in the past. It's something relatively new. Although some officers have done it just spontaneously to protect themselves, it wasn't particularly trained. So it's a relatively new concept, and they went into this training mode. It was a trained procedure. There was a belief, although mistaken, I called it reasonable, and they fired through their window.
Let's talk about Officer Brelo.
Officer Brelo. Officer Brelo fired through the window.
You say there, you're referring to another officer.
Officer Moore, who was with him, also did.
Okay. And let me ask you this, would you agree that to execute an ambush training procedure is kind of a last ditch, last desperation?
That is. I mean, because you couldn't do anything else. There are other tactics that could be involved. I just simply said, well, given what he did, given that they had training on it, I would call it reasonable. But there are other procedures that may have indeed even been better, but I had to say that was reasonable.
Wait a minute. If I'm Officer Brelo and I'm sitting in this car and I see this person coming at me with a dark object pointing at me, what else am I going to do but shoot through the car?
Well, I called that reasonable, but we do train for another tactic basically first. It doesn't mean because first makes it unreasonable.
Right.
In other words, there are reasonable alternatives.
Right.
I had to say, well, this is what happened, so it was reasonable. But basically, he put his car in P for park, and he should have been putting it in R for reverse. Because if they're coming at him, then he wants to put his car in the best position for him or her, or in this case, both of them, to utilize his car for cover and or if it should get struck. And he was not in that position. So he had a moment, in my opinion, the other procedure would be to put the car, it is not retreating, it's tactically repositioning. So there is another tactic. I didn't go into it because I wasn't going to say he acted unreasonably.
So he had some choices.
Yes.
He had reasonable choices, and one of his reasonable choices was to do ambush training.
That's correct.
He had other choices, but he didn't do that.
I think the other choices would have been better, but that's not the assessment one needs to make. I think
you're not being a Monday morning quarterback.
I'm going to look at what he did, and if it's reasonable, it's reasonable,
right.
And you need to move on.
Right.
Period. I mean, sure, you could have done this and you could have done that, and I don't like it when people start all the could haves, unless the one they chose was not the training. Then there is the could haves. He could have because the training said you do this, and he did not do that.
Okay, so when the victim's car was coming at Officer Brelo, and he had that perception that there was a dark object being pointed at him, when he did his ambush training, that was reasonable as far as you go, correct?
I said that, and that was my opinion. That's
okay.
correct.
And then what did Officer Brelo do based upon your review of the facts after he did his ambush training? What occurred after that?
Well, there is some concern I have about where he reloaded and the amount of rounds expended and so on, and I don't know that it makes a big critical difference, but he thought he had a jam in the car, and he thought he fired 4 or 5 rounds or 5 or 6 rounds, and then he reloaded with another magazine, which would have left one magazine in the car, and then he would have been out with a new magazine after having reloaded.
Wait a minute.
Well, I didn't see that in the report either, but overruled at this point.
Okay.
Judge, these are facts that are in the reports.
Right, but there are facts that are in, as I understand it, the Attorney General's summary.
Right.
But I don't see his opinion in the 12-page report where he says it was not correct or not reasonable or not a good decision to leave one magazine behind.
I'm not asking his opinion, Judge. I'm just asking his rendition of the facts. That's all I'm doing.
But I heard you ask him.
I'll rephrase your thing.
If I may, it wasn't the question, it was the answer, because he indicated some difficulty, which gets into the opinion part.
At this point, overruled, but you should, sir, confine yourself to testifying to opinions that everybody has notice of, including the defendant.
Yes, Your Honor, and I wasn't attempting to give an opinion. He said, what else happened?
Okay.
And I was just saying what happened.
I'll rephrase. So Officer Brelo exited his vehicle, correct?
Yes.
Okay, let me have a little blue guy here. So Officer Brelo shot inside the car, correct?
Yes.
And we ambush training?
Yes.
That's reasonable?
Yes.
And by you mean being that's objectively reasonable, correct?
Yes.
So any other officer...
Given that they had the training, it was objectively reasonable. I'm not certain that I would have indicated that had they not been trained to specifically engage in that manner.
Okay. But any other officer would have done the same thing, basically, what you're saying.
Yes.
So he reloads in his car and he goes back to shoots across here, correct?
Yes.
When he shot it, getting out of his car and shooting across, what did you opine on that?
I said that wasn't unreasonable, objectively reasonable. I think that he's still shooting, considering the threat.
Okay, and then he goes behind the 238, correct?
Yes.
And what happens then?
I'm not sure how he's perceiving. I only know what he said. He believes the car is still moving. I cannot imagine the car is still moving.
Why is that?
Well, because it was jammed up against 238. He said that the car struck 238 as he was putting it in park. So it's already struck 238, and we know it never moved beyond 238. So it had to have come to, if not a slow grind, a stop.
Overruled, go ahead.
So there was actual creases in this police car, correct? You saw the picture?
Right, but when he's behind the 238 vehicle and indicates that the car is still moving and I'm fearful that I'm going to get run over or pushed underneath, the car is to the side of 238, so therefore he can't go under the car. The car isn't coming at him. I'm not certain at all what he's perceiving, but it's inconceivable that the car was moving as he indicated it was, because he said it struck 238 before he got out of his car and as he was putting it in park.
Yeah, but what if the car kept going?
Well, it didn't, but it could have moved a little bit as it struck the front and then came to a stop.
So if he was behind here and the car kept going, he wouldn't have been pinned under the car.
No.
He would have gone by.
Right, here, this one's the snare.
Okay. So he's in the back of the car. Okay. What else was he perceiving pursuant to his statement that you reviewed?
That he sees officers to his left that are shooting in an area that there's a little hill behind them, and he sees them shooting towards the suspect vehicle.
Okay. And then what does he do pursuant to his statement?
He believes at that time, according to his statement, that he needs elevation, and he jumps onto the trunk of 238.
And he expends rounds up there, correct?
And he shoots from there over, he said, the light bar into the vehicle. I'm not sure how you do that from the trunk.
Opinion not given prior to trial. There's no statement whatsoever in his report about being on the trunk of 238.
Well,
He reviewed the facts.
hold on. Just cross-examine him on his, according to you, faulty rendition of the facts.
Okay. So he gets on the trunk and expends on the trunk of the 238, correct?
Correct.
And then his movements go where? Sir?
And then moves up to a little further up and then over onto, apparently, I don't know the exact movement, jump, climb, crawl. He got stepped onto the hood of the suspect vehicle.
Okay. Sir, do you have an opinion as to his actions after he left the back of the 238?
As I did opine in my report, that everything after that point is unreasonable, objectively unreasonable.
Objection, Your Honor.
Overruled.
You mean getting on the trunk and firing over the light bars?
As I indicated, everything at that
Well,
point.
actually, that's sustained though as to the leading nature of the direct exam.
Okay.
Let's at this point get into some true direct exam.
All right, sir. So, sir, do you have an opinion as to what happens after Officer Brelo leaves cover from behind the trunk?
Objection, Your Honor.
Sustained. I've heard his opinion on everything after being on the ground at the rear 238.
Sir, do you have an opinion as to whether Officer Brelo's actions that night, shooting from the trunk and then on the hood, was objectively reasonable or not?
I rendered the opinion it was not. I rendered the opinion on page 10 that it was not. All of the actions after he stepped behind car 238, I just simply summarized, all of those actions afterwards were objectively unreasonable.
And that is the degree of professional certainty, sir?
Correct.
Reasonable degree?
That's correct.
Why, sir?
Because at that point, he is taking action that is not trained, not recognized, not safe, and put all the other officers in the vicinity at risk of his becoming a victim and their having to attempt to now engage to save his life. We train in civilian law enforcement that you attempt to utilize whatever force or deadly force you can from cover and concealment so that you don't put yourself in a position to be shot or injured, causing other officers now to have to themselves risk their lives to attempt to save you.
Well, he was in cover here, wasn't he?
He was in cover. He had cover there.
Okay.
The minute he's on anywhere after that point, as I rendered my opinion, everything after that was not.
Well, he perceived a threat from here. He perceived that these individuals were shooting at him while he was still behind there.
And that's a point where he could have stayed or gone to the other side of 238. In any event, that would allow him to be where other officers were already positioned and to keep him from being in the crossfire of the other officers firing at the suspect vehicle.
Yeah, but he was in fear of his life. He was in a firefight.
Objection, Your Honor.
Sustained, let's have direct exam, it's not cross of your own.
Based upon your reading of Officer Brelo's statement, did he indicate to you whether he was in fear of his life at that point?
He said he was in fear of his life more than any other time in his life. That's right.
And in his statement, did Officer Brelo not say that he was fearful of a threat from the car?
Yes.
Did he also not state in his statement that he thought he was in the middle of a firefight?
Yes.
But then why would it be unreasonable for him to get up and eliminate this threat?
For the exact reasons he gave for why he did what he did, which were, in my opinion, not objectively reasonable decisions
What do you
to
mean?
make.
Explain it.
Because if you are in fear of your life and you're behind cover, I can't imagine the fear that you're going to have when you put yourself standing on top of a car in the middle, as he called it, a firefight. That is not trained. It's not appropriate. It's not objective. And whatever subjective belief he had about his fear at that moment was not objectively reasonable to put himself up in the middle of both crossfire and the potential of being shot either by officers or the suspects, which would then jeopardize the other officers who would have to go into a mode of saving the officer that's now down. You don't put yourself in a position of officer down in the middle of a situation that he was involved in. That's why it's objectively unreasonable. It's not trained. It's not appropriate. It's taking yourself out from behind cover, and you're putting yourself in crossfire, and you're putting the other officers in jeopardy of having to now, if you get shot, save your life, which risks their lives.
Well, aren't you playing Monday morning quarterback right now?
No,
Why not?
because I'm a trainer and I'm talking about police training that's universally accepted throughout the country. That's not quarterbacking. We have to evaluate conduct for officer-involved shooting situations, not only for learning for the future, but also to determine whether or not the officer acted according to the law and his or her training.
So what you're telling me, even though he was, as he indicated, Officer Brelo was the most afraid and scared of his whole life, and there's shots coming from him that he believes out of here, to get up on the car and eliminate that threat was not a reasonable response?
No.
Sir, in your experience, and how many years have you been doing this, since 1960?
I've been in law enforcement 52 years.
And how many use of force situations have you reviewed in those years?
Well, dozens and dozens and dozens. I don't have a count, but I'm confident it's well over 1,000.
Okay. those, have you ever seen or heard of a circumstance where somebody jumps on the hood, trunk and then hood, to eliminate a threat?
Objection.
No.
No, I have never heard of it, and I believe it's because it would not be objectively reasonable. It's not trained. It would be improper. It would be putting your life in jeopardy and the lives of other officers at risk who would have to try to save your life.
And sir, just getting back to some of your initial discussion, at this point when he's back here, what should be kicking in, based upon your opinion?
His training.
His training. And what did his training should have told him to do?
Cover, threat assessment, commands.
What does that mean?
That means you stay behind cover, you assess the threat that's going on at the time. If you believe there is shooting occurring, you don't put yourself into the middle of the shooting by going up on top of a vehicle while there's officers firing from the left, officers firing from the right, suspects firing from in the middle. That is the time to assess that threat and stand your ground behind a cover to protect your life, to make certain that others don't have to jeopardize their life because you've done something completely foolish and completely outside of your training.
Well, sir, according to Officer Brelo's statement, he felt he was going to get pinned behind this car.
I don't understand how that could possibly happen. That may have been his subjective belief, but that is not objectively reasonable given the totality of the circumstances and a vehicle that did not move more than a couple of feet after it struck 238. And that was way back when he put his car in park, before he ever fired out of the windshield, before he got out of his car and laid down some more fire towards the vehicle and then sought cover.
Hold on. Overruled. You can cross-examine him on this subject.
But, sir, doesn't it make a difference that he was in the middle of a firefight?
Well, I'm not sure what you mean, doesn't it make a difference? It obviously makes a difference, but it doesn't make a difference that you can jeopardize your life to cause other officers to have to risk their life and come out from behind cover and elevate yourself right up into the middle of crossfire. Sergeant Coleman said a couple of times, watch the crossfire. That's one of the assessments for threat that officers have to consider, is crossfire from the suspects and from other officers.
And sir, you reviewed the other 12 shooters, correct?
Yes.
And opined that their actions were reasonable.
Mistaken, but objectively reasonable.
And, sir, does it make a difference in your opinion whether any of these officers were indicted?
No.
Does it make a difference whether any of these officers were administratively disciplined? Does that
No.
have any effect on your opinion?
My opinion, and I went over what everybody did and how I came to my conclusions, and indicated that certainly there were mistaken beliefs and some inappropriate supervision that took place. I did opine that. But I was looking specifically at where the deadly force became objectively unreasonable.
What I'm trying to say is any of these officers, in your opinion, that acted objectively reasonable, does that somehow cross over or corroborate or somehow affect the opinion of how Officer Brelo's actions were?
Right.
Was your opinion any different because of these other officers' actions were reasonable? And your officer?
Any different than what? I mean, this is sustained too. Let's just have a question on direct, not your closing argument.
Thank you, Your Honor. Sir, were you able to read Mr. Martinelli's opinion, sir?
Yes.
The defense opinion?
Actually, let me interrupt you at this point, Mr. Goodyear. We're going to take a break. So, sir, you're about to be asked some questions about Rod Martinelli's opinions, but for now we're going to take a short break. You have to return to the stand in about 15 minutes if you remain under oath.
Thank you, sir. Thank you, Your Honor.
Let's say 11:30, please.